Can you see openly wealth?
Would that be on the actual mic itself or on the...
Hello. Welcome, everyone. I'm Ann Knigendorf. I'm a writer and editor here at the Kansas City Public Library. And before we talk about tonight's program, I'd like to call your attention to some upcoming events, as I like to do. And so next Tuesday evening right here, we'll have a program called The Racial Wealth Gap. Journalist Ebony Reed in Kansas City and Beverly Renty will talk to the Kansas City Star's Marae Rose Williams about the racial wealth gap. Reed, who lives in Kansas City, has written a book called 15 Cents on the Dollar, How Americans Made the Black-White Wealth Gap. Reed and her co-author chronicled the lives of 7 Black Americans of varying economic levels, ages, and professions to tell the story of the economic struggle many Black Americans face. And on Saturday, August 3rd at 1 o'clock at the Central Branch, we have an exciting hands-on program. Has anybody been over to Central and seen the exhibition called Fictions? It's a bunch, some people have. So they're reimagined used books that have been deconstructed and reconstructed as sort of sculptural collage. They're very cool. But the artist who created those, Andrea Bergay, is a Brooklyn-based artist, and she'll be here on August 3rd to do a talk, and there will be a reception, and then she'll do a hands-on workshop with our own exhibition specialist, Craig Augie. So please check kclibrary.org for more details and to RSVP. A lot of you I see out there regularly attend our programs, so you're familiar with our usual format that we follow, and tonight will be slightly different. After our featured speaker's presentation, we'll introduce 3 more guests who will come up and give a local perspective on what the presenter has just said, and then we'll go to audience Q&A. So this evening's program is another great one suggested by the Women's Equality Coalition of Kansas City, and we appreciate so much that they continue to give us these great speakers and authors that we may otherwise have missed, but maybe sometimes not, but we're always glad for their input. To introduce our guest tonight, I'd like to welcome Alice Kitchen. She's the co-founder, along with Gail James, of the Women's Equality Coalition. For over 20 years, Ms. Kitchen was the Director of Social Services at Children's Mercy. She's an activist who's served on many boards and committees. The White House even awarded her a Champion of Change Award. She's an advocate for many women's issues around the Equal Rights Amendment and cities for the elimination of all forms of discrimination against women and girls in all their diversity. Please welcome Alice Kitchen.
Welcome, everyone. Our Women's Equality Coalition is so glad that you're here, and we're so grateful to the Kansas City Public Library for bringing Leigh Goodmark to Kansas City. The Women's Equality Coalition has been around since 2012. We consist of 11 women's organizations, and our purpose in life is to increase the awareness of women's rights wherever they need to be increased. Gender violence is so deep in our world history and in our culture. And we're grateful that the library recognizes that this is a challenge for all of us, not only domestically, but worldwide. Our speaker tonight, Leigh Goodmark, is an author of 2 books. 1, Decriminalizing Domestic Violence, and 2, the one you're going to hear about tonight. And that one is Imperfect Victims, Criminalizing Survivors. She is the Associate Dean for Research and Faculty Development at the University of Maryland. She teaches gender, prison, and trauma clinic. Her works are groundbreaking. They are on intimate partner violence. She's appeared in numerous journals, law reviews, publications, including Violence Against Women, New York Times, the Harvard Civil Rights and Liberties Law Review, the Harvard Journal on Gender and Law, and the Yale Journal of Law and Feminism. Welcome, Leigh Goodmark.
Thank you so much. It's such a pleasure to be with here. Thank you for coming out on a kind of a nasty night. I very much appreciate it. And I want to hop right in because we don't have enough time ever to talk about this stuff. Oops, our slides seem to be hung up. Do it. I can't even find the mouse. Yeah. See, and we were doing so well. So I want to start by telling you 3 stories. This is Renata Singleton. Miss Singleton's boyfriend, Vernon Crossley, destroyed her cell phone during an argument, and the police arrested him. Shortly thereafter, the New Orleans District Attorney's Office contacted her and she told them, I don't want to prosecute this case. I've got kids, I've got a new job, I broke up with this guy, not interested in doing anything more. I'm not involved with him. Nonetheless, prosecutors delivered a subpoena to her door telling her that she had to appear in court. When she decided not to comply with the subpoena, which was illegal, but that's a whole other story, she did not go to the meeting that she was subpoenaed for. Prosecutors went to the court and asked the court to issue what's called a material witness warrant, a warrant that would have her jailed until such time that she testified. And the judge issued that warrant and set her bond at $100,000. After she became aware of this warrant that was out for her arrest, Ms. Singleton went to the district attorney's office and said, I don't want to answer any questions without having an attorney here. And was told, well, you don't get an attorney because you're the victim. When she still refused to answer questions, she was arrested, handcuffed, and taken to the Orleans Parish Prison. And because she could not pay the $100,000 bond, she was held for the next 5 days. When she finally appeared in court, she was wearing an orange jumpsuit. She was shackled hand and foot and chained to the other people who were appearing in court that day. She was then released on a reduced bond of $5,000, given a curfew and an ankle monitor. What happened to Mr. Crossley, you might be asking? Well, Mr. Crossley had a very different experience with the criminal system. His bond was initially set at $3,500. He paid the bond, he was released on the day that he was arraigned. He pled guilty to 2 misdemeanors, and of course, because he pled guilty, prosecutors never needed her testimony at all. In the upper corner is Tracy McCarter. Tracy McCarter's ex-husband, James Murray, had abused her for years before the night that he came to her apartment drunk, demanded money for alcohol, and then assaulted Tracy. Ms. McCarter, forgive me, I call her Tracy because I know her. Ms. McCarter picked up a knife to defend herself, and in the ensuing struggle, her husband was stabbed. Ms. McCarter screamed for help. She called 911, and as a nurse, she worked to stanch the bleeding until the emergency services came. She was arrested. She was held on Rikers Island. And prosecutors said she's not a victim of violence. So we don't have to worry about these claims that she's making, that she acted in self-defense. They alleged that she had been previously violent against her husband, although the police report from that incident states that it involved a verbal argument, that Mr. Murray was too drunk to stand up when the police actually came, and that he had not been physically injured in any way. Prosecutors argued that Ms. McCarter was not afraid of Mr. Murray and stabbed him either because she was jealous of his affairs with other women or because she was trying to prevent him from stealing her purse. Ms. McCarter's defense attorneys repeatedly asked the court to set bail, saying that she is not a risk, she acted to defend herself, she is a nurse, it is the middle of the COVID pandemic, we need her services. And prosecutors continued to oppose her release on bail, saying that the argument that she is a victim is nothing new. She was finally released on electronic monitoring after spending 6 months on Rikers Island. And after 2 years of advocacy, the Manhattan District Attorney dropped the charges against her. In the bottom corner is Tanisha Williams. Tanisha Williams was 20 years old and a victim of repeated sexual, physical, and emotional abuse, the mother of 2 young children, and unhoused when she met a man named Patrick Martin. Ms. Williams had been doing survival sex work. Mr. Martin offered her a place to live in exchange for sharing the bills. And what Ms. Williams didn't know when she took up on that offer was that he intended to pimp her out. And when she told him that she wasn't going to do that, he began beating and strangling her, stealing her money, and forcing her to care for his household and his children. Mr. Martin always carried a gun, and Ms. Williams was afraid that he would use it on her. But she didn't want to go back to sleeping in cars. So she thought she would stay there until she got enough money together that she could move out on her own. On December 29, 2002, a man named Kevin Amos came over to the apartment where Mr. Martin and Ms. Williams were living. Believing that Mr. Amos had looked at him disrespectfully, Mr. Martin punched and pistol whipped Mr. Amos, who lost consciousness. Mr. Martin ordered Ms. Williams to tape Amos's mouth and nose closed. And when she began to scream, he picked her up, threw her against the drywall so hard that it cracked the drywall, then held her with his arm up against her throat until she could not breathe. And then he dropped her to the ground, and he said, "Get down or lay down." And what she understood that to mean was, you comply with my order or I will kill you too. And she was right about that. I know that because I have an affidavit signed by Patrick Martin that says so. Patrick Martin said at that time she was terrified. I told them, if you don't do it, I'm gonna do you. So they did it, but it was out of fear. The case went cold for 7 years. But in 2009, Ms. Williams decided to tell the truth. She hoped to give Mr. Amos's family some closure, and so she told the police everything that she knew about the crime. She testified against Mr. Martin, who was convicted of first-degree murder and sentenced to life in prison. Ms. Williams believed that police and prosecutors would understand that she had only complied with Mr. Martin's orders because she knew that he would kill her if she did not. But what she didn't know was that even though she had acted under duress, that didn't matter, because duress is not a defense to intentional homicide. It's not a defense to murder in Michigan, as in most states. As the prosecutor in Ms. Williams' case argued, the law does not allow one person to sacrifice the life of an innocent to save their own. The law says, no, you can't do that. You've got to resist. You've got to take your chances. We have twice asked the governor of Michigan to commute Tanisha's sentence. She is my client. I have her permission to talk about her case. And so far, we have not been successful. All of these women share at least two things. They were victims of gender-based violence, and they were punished by the criminal legal system as a direct result of the violence that they had experienced. But these stories are not new. On June 23rd, 1855, an enslaved woman named Celia, only her first name is known to us, fought off her master, Robert Newsom, with a stick, killing him. Newsom had repeatedly raped Celia over the 5 years since he had purchased her when she was 14. Celia told Newsom that she would fight if he tried to rape her again, and she told his daughters the same. But Mr. Newsom persisted. So after she killed Mr. Newsom, Celia put his body in the fire and then removed his bones the following day. Now, Missouri law at the time permitted women to argue self-defense in resisting rape, but the judge in Celia's case refused to give the jury that instruction. By law, Celia was property, not a person, and therefore she could not be raped. Instead, the judge told the jury that if Newsom had been used to having intercourse with Celia, went to her cabin to do so, and she struck him and killed him, she would be guilty of first-degree murder. On November 1st, 1855, Celia was in fact found guilty of first-degree murder. She was hanged a month later. In 1948, Rosalie Ingram and her two sons, Wallace and Sammy Lee, were convicted by an all-white Georgia jury of killing a man named John Stratford. Wallace hit Stratford with a gun when Stratford tried to rape his mother. Ingram and her sons, then 16 and 14, were sentenced to death. That sentence was later modified to life in prison, and they were freed in 1959 after sustained advocacy and organizing on their behalf. And then in 1974, feminists rallied around Joanne Little, a 20-year-old black woman who was charged with killing Clarence Alligood, a 62-year-old white correctional officer in the Beaufort, North Carolina jail. Mr. Alligood was found dead on the bunk in Ms. Little's cell with semen on his thigh. He had been stabbed 11 times. Ms. Little explained that Mr. Alligood came to her cell carrying an ice pick, which he used to force her to have oral sex with him. She grabbed the ice pick, he grabbed her neck and shoved her to the ground, and as she was complying, he dropped the ice pick, and she picked it up and stabbed him with it. After a little over an hour, a jury consisting of both black and white members acquitted Little, who was then returned to prison to finish her original sentence. Like Renata Singleton and Tracy McCarter and Tanisha Williams, Celia and Rosalie Ingram and Joanne Little, many, if not most, of the women who've been tried and convicted for attempting to protect themselves from violence are and were black women. For the last 40 years, the criminal legal system has been the primary response to intimate partner violence in the United States. Criminalization was supposed to increase our understanding of gender-based violence and decrease the level of that violence by changing community norms around its acceptability. But one of the serious consequences, and perhaps the most serious consequence of those efforts, has been the increased rates of arrest, prosecution, conviction, and incarceration of those who these changes were meant to protect, victims of violence. So many victims of violence have been caught up in the criminal legal system in recent years that a whole movement, known by the hashtag Survived and Punished, has emerged to protest their re-victimization by the criminal legal system. Now note that I didn't call this an unintended consequence. Because women of color, particularly black women in the United States, warned from the beginning of the anti-violence movement that increasing the reach of the criminal legal system would harm women of color. And we have seen those results for far too long now to argue that those consequences are unforeseen. Part of the reason that the criminal legal system comes down so hard on these women is because they are imperfect victims. The criminal legal system likes perfect victims, blameless victims, who are meek and weak and passive and white and straight and cisgendered. Victims of violence, though, don't always or even often conform to those stereotypes. Sometimes they're angry. Sometimes they fight back. They do sex work. They use substances. They have mental health issues. These are all imperfect victims, and these imperfect victims face harsh punishment from the legal system. So victims usually come into the criminal legal system in three ways. One, just as a result of their victimization. Two, as witnesses. Or three, as criminal defendants. In 2017, Cassandra Jackson sought an order of protection, protecting her from her partner's abuse. When the order was denied, she slapped a sign on the wall of the courtroom. Magistrate Michael Bachman ordered her incarcerated for 5 days for contempt of court as a result of her belligerence. In 2018, Ms. Jackson returned to the same court to seek another order. And when she was told it was too late in the day, she began to plead with the person. Magistrate Bachman, who was again sitting in that court, heard what was going on in the hallway, left his courtroom, chased Ms. Jackson down, grabbed her, and dragged her back into the courtroom, where he again found her in contempt and again sentenced her to imprisonment, this time for 10 days, again because of her belligerence. People come into the system as witnesses. So we talked about Renata Singleton already. In Tennessee, Washington County, Tennessee, over a dozen victims of intimate partner violence were jailed on similar kinds of warrants after they declined to participate in prosecution. Prosecutor Tony Clark defended this policy, saying that prosecutors needed to send a message. He said, "I'm not going to go back and apologize for what we've done because I think we were doing the right thing. At some point in time, where do we draw the line in saying that we're just going to dismiss these cases if a victim doesn't appear?" Donna Oliver, one of the Tennessee victims who was jailed after failing to appear, described how she was, quote, grabbed by both male and female guards, thrown down, sprayed, had every ounce of clothing taken from me, even my glasses. My knees were badly bruised. You could see grab marks all over my legs. Correctional officers admitted that they had, in fact, used force and chemical spray against Oliver, a witness, you remember. And notwithstanding Oliver's claims, Prosecutor Clark said, "Do I think we're re-victimizing victims? No, I don't." And then, of course, people come into the criminal legal system as defendants because they use force against a partner for whatever reason, most often self-defense, because they commit crimes at the direction of or out of the fear of their partners, because they are self-medicating. I could keep going, and I will, of course, over the course of the presentation, and often are held accountable for crimes committed by other people, including the failure to protect their children from their partner's abuse. So my book, Imperfect Victims, starts where many criminalized survivors first become involved with the system as children, and then walks through the other stages of the criminal legal system. Between 75 and 93% of girls have experienced some form of physical, sexual, or emotional abuse before they come into the juvenile system. So why are we arresting children? Well, police officers will tell you it's for their own good, because we need to get them off the streets so that we can have them testify against their traffickers. But often it's also because police see these girls as criminals, girls who are not ladylike, who are perceived as angry or confrontational, who run away, who act in self-defense, who use illegal substances or express their sexuality or engage in sexual behavior, whether voluntarily or involuntarily, lose the protection that girlhood could confer upon them and are sometimes punished more harshly as a result. In the context of trafficking, for example, law enforcement officers often have trouble distinguishing being trafficked from engaging in volitional sex work, which, by the way, under federal law, you can't do if you're under the age of 18. And say because girls choose to engage in prostitution, they need to be held criminally accountable. And all of these problems are worse for girls of color, particularly black girls, as well as for lesbian, gay, bisexual, and trans and gender nonconforming youth. This is 14-year-old Brescia Meadows, who shot and killed her father, who had abused her mother and raped Brescia for years prior to his death. She was incarcerated in a juvenile facility pending trial, then pled guilty to involuntary manslaughter and was sentenced to 1 year and 1 day in juvenile detention, followed by 6 months of inpatient mental health treatment. She was released on probation in October of 2020. Brescia compared being in a juvenile detention facility to living in her father's abusive home. She said, "It kind of triggered me being in there. I'm like, y'all don't understand. I've been through this." Highly restrictive programs for girls are essentially recreating the situations that girls have faced in their abusive homes. And this, by the way, is a decent juvenile facility. It's actually clean, or at least looks like it in the picture, so imagine how much worse it can be. Moving into the adult system, the person you can't see in this photograph is Simone Phoenix. Ms. Phoenix went to the Providence police station to get an application for emergency housing funds after having been abused by her husband the week before. She wanted to move herself and her son out of the home that they shared with her husband and closer to her new job. So she met with 2 law enforcement advocates, people who are employed by local anti-violence organizations but embedded in the police station. And those advocates, after asking her a number of questions, told her that she needed a mental health vacation. And she said she couldn't afford to take a vacation given her job and her parenting responsibilities, and then realized that she needed to leave because her son was coming home soon. So she asked the advocates, "Am I free to go?" And they said that she was. She walked down the hall, she tried to enter the elevator, and then was told by 2 police officers in the elevator that she was not, in fact, free to leave. I just want you to remember she went looking for services, right? That's why she's in this police station. As the officers surrounded her, Ms. Phoenix told them that she suffered from post-traumatic stress disorder and that they should not touch her. And of course, the officers grabbed her nonetheless. Ms. Phoenix panicked. She swung her arm to protect herself, and in response, the officers threw her to the ground, kicked her repeatedly, and handcuffed her so tightly that the fire department later had to remove the jammed cuffs. They dragged her down the hallway by her hair. They placed her in a holding cell. They left her there for 3 hours. Then they took her to the hospital and told the hospital staff that she was suicidal. Providence police later charged Ms. Phoenix with simple assault and malicious destruction to property. After 7 court appearances and the loss of her job, all of the charges were dismissed. This is not an anomaly. Significant numbers of victims are arrested. In a 2022 survey of victims of intimate partner violence conducted by the National Domestic Violence Hotline, 25% of victims who had called the police said they were threatened with arrest when reporting an incident to police. 12% were actually arrested. And arrest rates are higher in traditionally marginalized communities. So according to Connie Burke, the executive director of the Northwest Network, which is an anti-violence organization serving lesbian, gay, bisexual, and trans and gender nonconforming clients, in 1 year, fully 50% of their clients who had contact with police were arrested. The experience of arrest is traumatic. Erica describes her arrest this way. "So all of a sudden, 2 cops came running down the hallway, and I remember the leather on their belts. That noise scared me. I remember the leather, and the things rubbing on their belt was something. Even talking about it now scares me. So the next thing I know, the cop grabs me brutally by the arm and slams me, my face, against the door." An arrest has lots of consequences beyond just the trauma of being arrested, the frustration of being identified as an offender, sometimes after years of victimization, and the stigma of the publicity around an arrest. Arrests are expensive, even if charges are ultimately dropped. The costs of arrest include cash bail or bail bonds fees, bills for legal representation, monitoring fees for people released under supervision, and decreased income as a result of lost employment. Being arrested creates a permanent record that can be accessed by police and the public. It can lead to the denial or suspension of occupational licenses, an inability to access public benefits, and the loss of custody. Child Protective Services may become involved with parents who are arrested. Employers may decline to hire based on an arrest record. Your arrest could also lead to your termination from a job, as it did for Ms. Phoenix. After arrest comes prosecution. You have to understand something about prosecutors. Prosecutors decide who will be charged, what they will be charged with, whether to recommend diversion from prosecution, whether to ask that a person be detained until trial or granted bail, whether a plea bargain will be offered, who will be required to testify, and based on charging, what the likely sentence will be. And I'll come back to that in a minute. Because of the breadth of their power, prosecutors are the most powerful people in the criminal legal system. and they have almost unlimited discretion in the use of their powers, even when exercising that discretion leads to disproportionately punitive interventions against people of color. So while in theory, the primary obligation of the prosecutor is to seek justice, prosecutors may have other competing goals. Prosecutors may see their mission as securing convictions rather than seeking justice, or fail to see it when those goals diverge. Even progressive prosecutors have the potential to misuse their power. So why is it that prosecutors are pursuing these cases? Sometimes it's to rescue or to save. And so they use their powers, their coercive powers, to coerce participation using subpoenas and material witness warrants to save people like Renata Singleton. They take cases forward when they think they can win, and prosecuting victims of intimate partner violence who use force is actually pretty easy. Those are winnable cases because victims tend to tell the story in detail. They're less likely to argue that they're innocent. They're often eager to plead. Prosecutors are more likely to pursue cases when there's a weapon involved, including in self-defense cases, or where someone has a prior criminal history. Again, a disproportionate number of the women who are prosecuted for intimate partner violence are women of color, particularly Black women. But most often, prosecutors prosecute because they don't believe the defendant is a victim. Prosecutors regularly counter victimization claims by arguing that the defendant was angry or jealous rather than afraid, that the violence that they're describing as occurring to them was minor, that the defendant could have left the situation rather than committing a crime, and that strong women, women who can hold their own against their partners, couldn't possibly be abused. So some of you may have watched the Netflix documentary Killer Sally. Sally McNeil killed her husband Ray after years of abuse, and Sally McNeil transgressed the norms associated with victimization in almost every way. She was a Marine, a branch of the armed services noted for its machismo. She was a heavily muscled, physically strong woman. She was a champion bodybuilder. She was the primary breadwinner for their family. She wrestled men for money, so she was selling access to her body. She brawled with everybody, neighbors, police, and the women her husband was dating without her consent during their marriage. She used inappropriate language. She physically fought against her husband. Despite the physical evidence of Ray's abuse of Sally, and the witnesses who testified to hearing Ray strangle Sally on the night of his death, prosecutors dismissed her claims. Prosecutor Daniel Goldstein said she was a bully and a thug, and that a violent person can't be a battered woman. And sometimes prosecutors bring these cases to send a message. So after Joanne Gilliam lied to a federal grand jury about her boyfriend hitting her with a gun, prosecutors charged her with perjury and obstruction of justice. The prosecutors acknowledged that she was a victim and that she feared for her life if she testified truthfully. But prosecutor Stephen Shenning said just because she's wearing the mantle of a victim, that doesn't give her a pass on breaking the law. Once a person has been convicted, the sentencing decision is almost entirely the province of the judge. Judges can consider a number of factors, including conduct for which the person was not convicted or was acquitted, the number and type of the charges brought by the prosecutor, and recommendations from any number of different people. Judges also bring their own backgrounds, life experiences, perspectives, and biases to sentencing decisions. Now, I say judges have almost unfettered discretion because of mandatory minimum sentencing. Mandatory minimum sentences deprive judges of any discretion to show mercy based on mitigating factors. So they require judges to give the same minimum sentence to every person convicted of a particular offense, regardless of the context. This gets us back to prosecutorial power. When prosecutors charge someone with a crime that carries a mandatory minimum, they can deprive a judge of discretion from the outset of a case. And those mandatory minimum sentences give prosecutors leverage by creating incentives for defendants to plead to reduce a charge with a long mandatory minimum to a lesser charge carrying a shorter and possibly discretionary sentence. Now, there are states that have laws that allow judges to depart from the mandatory minimum sentence in cases of domestic violence. Under New York's Domestic Violence Survivors Justice Act, a sentencing judge can, but is not required to, determine whether the defendant was a victim of domestic violence at the time of the offense, and if the abuse was a significant contributing factor to the crime. If so, the judge can find that the mandatory sentence is unduly harsh and hand down a shorter sentence. Nikki Armando was the second person to seek relief under the Domestic Violence Survivors Justice Act. Described as the freaking poster child for the DVSJA, Armando presented evidence at trial that her partner, Christopher Grover, had abused her for years. Police, medical professionals, victim services agencies, and child protective services workers in and around Dutchess County, New York, all had records that documented her abuse. On the night that she shot Grover, Armando testified he had cleaned his gun, put several bullets in, and then showed her a diagram of the brain, noting where he could shoot to kill and where he could shoot to permanently impair her memory. He then sexually assaulted her and then ordered her to sleep with him on the couch. When she pulled away, the gun fell to the ground. She grabbed it and she pointed at him and he said, "Here's what you're gonna do. You're gonna give me the gun, I'm gonna kill you, I'm gonna kill myself, and then your children will have no one." And sure that he was about to kill her, Armando pulled the trigger. Prosecutor Hannah Kraus attacked Armando's credibility and character. The prosecutor argued that Armando's narrative of abuse was inconsistent, that the injuries that could be seen in the photographs of Armando could have been self-inflicted or the result of foreplay with her other sexual partners. The jury ultimately found Armando guilty of second-degree murder, apparently agreeing with the prosecutor that she just wasn't a victim. And the judge agreed too. Asked to apply the Domestic Violence Survivors Justice Act in Nikki's case, McLaughlin declined. He found that the evidence of abuse that she had offered was inconsistent and undetermined, and that Armando could have used the tremendous amount of advice, assistance, support, and opportunities to escape her alleged abusive situation rather than killing her partner. At sentencing, Armando told the court, "I wish more than anything this ended another way. If it had, I wouldn't be in this courtroom, but I wouldn't be alive either, and I wanted to live. I wanted this all to stop. I was afraid to stay, afraid to leave, afraid that nobody would believe me, afraid of losing everything. This is why women don't leave. I know that killing is not a solution and staying hurts, but leaving doesn't mean living. So often we end up dead or standing or where I'm standing, alive but still not free." McLaughlin sentenced her to 19 years to life in prison. He called her a broken person and said, "When you boil it all down, it comes to this: you didn't have to kill him." The appellate court ultimately found that McLaughlin was wrong. They reduced Nikki Armando's sentence to 7.5 years, and then she sat in prison for 7.5 years. She was recently released. There's a fantastic book called Dear Sister that her sister Michelle Horton has written about her case and everything around it. It's worth listening to. I could spend another whole talk on punishment. I'm quickly running out of time, so I can't do that. Suffice it to say that prisons are trauma-inflicting institutions. Even the best prison, as though such a thing could exist, is not a place where anyone, let alone a victim of trauma, should be kept, and US prisons are far from the best. So, the criminal legal system routinely punishes victims of gender-based violence. That punishment begins when victims are children, continues when victims seek protection from the state or are compelled to participate in prosecution, and is at its apex when victims become defendants in criminal cases. Victims are detained, arrested, prosecuted, sentenced, and incarcerated. They are placed on sex offender registries. They live under draconian conditions of parole. Criminalization was intended to benefit victims of gender-based violence, to keep them safe and ensure that those who harmed them were held accountable. Instead, the criminal legal system has done immeasurable damage to those it was meant to protect. And for some people, the answer to this is reform. We can fix the parts of the system that are harming victims of violence while leaving the overall apparatus of state punishment intact. But reforms cannot and will not prevent the punishment of survivors of gender-based violence. Reforms assume that we can fix the carceral system. We can add defenses, we can have diversion programs, we can change the sentencing laws, we can make prisons better. We can do gender-responsive and trauma-informed prisons. Don't even get me started on that. All of these reforms are well-intentioned. Some respond to real problems in the criminal system. But because they largely accept the intervention of the criminal legal system as a given, they have the potential to do serious harm and to preempt the kind of change needed to prevent survivors from being criminalized in the first place. All of these reforms require actors within the system to use discretion wisely, but these actors misuse their discretion all the time. Discretion is what allows police and prosecutors and courts and executives to rely on victim stereotypes to dismiss the claims of criminalized survivors. Discretion allows law enforcement to blame victims who fail to turn to the criminal legal system for help. Discretion creates space for judgments that the failure to leave or call police or assist with prosecution means that a victim's story is not credible. Discretion masks implicit bias and outright racism in how police and prosecutors exercise their power. And most of all, it doesn't focus on any of the structural factors that bring people into the system, things like poverty and racism. Leaving the basic structure of the criminal system intact legitimates that system and preempts more radical change. So I have argued, and I am in the footsteps of a long line of people to whom I owe huge debts. Angela Davis, Beth Ritchie, Miriam Kaba, Andrea Ritchie. You should be reading all of their work before you even look at mine. But they have all argued about abolition feminism. Abolition feminism is a feminism that opposes rather than legitimates oppressive state systems. And it's interesting that several notable abolitionists, including Miriam Kaba and Beth Ritchie, came to abolition through the anti-violence movement. They saw the damage that had been done by the movement's collusion with the state to build repressive systems to police and punish gender-based violence. They questioned how systems that regularly did violence to women and people of color and queer and trans people could keep victims safe. Now, I recognize that abolition is a lot, and it requires a leap of faith that many people are not ready to take. So, while my ultimate ask is abolition, to defund the structures that drive criminalization and dedicate that funding to other things, there are lots of things we can do along the way if you're not ready to go all the way to abolition. We can oppose new criminal laws that increase the reach of the carceral state. We can repeal existing laws that bring people into the system or keep them there. So mandatory arrest is a great example. Mandatory arrest requires police to make an arrest whenever they have probable cause to do so in a case of intimate partner violence. After the inception of mandatory arrest laws, arrest rates went up. Not surprising. They went up for one group more than anybody else, women. Not because women had become more violent, but because of the way that police were implementing those laws. We don't have to have mandatory arrest laws. We don't have to have mandatory minimum sentencing laws. We don't have to have felony murder laws, which are entrapping lots of women who are forced to commit crimes alongside their partners. We can eliminate cash bail, which keeps people trapped in court, forces people to take pleas that they would not otherwise take, punishes poor people for the crime of being poor. We can do survivor defense work. Amazing survivor defense work. It can be done around criminalized survivors, letter writing, financial support, visits to incarcerated people, fundraising to support the incarcerated person, all kinds of things. And so if you're familiar with campaigns like the Free Brescia campaign or the campaign around Marissa Alexander, that's survivor defense. We can work on clemency, asking chief executives to forgive people who've been convicted of these kinds of crimes. We should be opposing the construction of new prisons. Every time a prison is built, the job then is to fill it. And they've got to find somebody to fill it with. And especially if somebody tells you that a prison is going to be gender responsive or trauma informed. Gender responsive, in my experience, has meant, oh, we have sewing classes. We have cooking classes. And you can't have a trauma-informed prison. Prison is a trauma-inflicting institution. It cannot be trauma-informed. We need to be investing in prevention and offering alternatives to the criminal legal system. So I'm running out of time, so I'm going to finish up. This is what it looks like when a criminalized survivor is released from prison after serving 31 years of a life sentence for felony murder. Rodera Bailey's crime was being forced to clean up after her abusive partner committed a murder in her apartment. Ms. Bailey went to police as soon as he was arrested. She showed them where the murder weapon was, and she cooperated fully. And 5 months later, she was charged with the murder that he had committed. Ms. Bailey and tens of thousands of women like her should not have had to serve a day of that sentence. Angela Davis has long argued that those of us who work to end gender-based violence should be on the front line of abolitionist struggle. But abolition is a big ask, particularly for an anti-violence movement that had been founded in the belief that only carceral systems could save lives and hold those who did harm accountable. It is not an easy thing that we are asking for. Working towards abolition will take sustained effort over a long period of time, and change may be hard to see in the short term. But ensuring that criminalized survivors are no longer punished by the criminal legal system justifies this work. The only way to ensure that criminalized survivors are no longer punished by the criminal legal system is to eliminate that system. People created the carceral system. we can dismantle it, and we can build something healing and liberatory in its place. Thank you.
All right, thank you, Professor Goodmark. And now we're really lucky that we have three prominent local leaders who will offer their perspectives on Dr. Goodmark, or Professor Goodmark's presentation. First up, we have Jackson County Prosecutor Jean Peters Baker.
Okay, good evening. Who doesn't hate prosecutors now? Probably me too, right? So there are many things I could say, and I want to kind of drill down on just a few. One, the world, has changed and it continues to change, and I think folks like me, even people who work at law schools, need to embrace change and reform and how we can improve our systems, because I am not one that's going to defend my own system as being perfect. It's far from it. But there are elements of that system that we need to continue to use in order to have an orderly society. And even though it's fraught with the number of mistakes that are embedded into our system. And it's not just my system, the criminal justice system, it's all parts of America, our healthcare system as well. People of color are treated without the same fairness as most of us here in the audience. People who look like me, who are white, people who are fairly affluent. So if you come from an impoverished family, neighborhood, that will impact you probably in every part of American society, but certainly in the criminal justice system. If you're gay or trans, it will also have an impact. So I acknowledge that those things are true and things that we need to try and improve and make better. But I want to make this kind of final comment, and that is about the perfect victim. Prosecutors do want to have as perfect a victim as possible. That is true. But for somebody who has tried a number of cases, over 25 years in this business, over 75 cases I've tried, many of those in my career were victims of sexual assault, sexual violence. That's the category of cases I lost in the largest quantity. And it was painful and sometimes humiliating for the victim to be on the receiving end of a loss. And what I would always try and carry them through the system as gently as I could. The criminal justice system and trial work, when you go up against a defense lawyer, it's not therapeutic. It's not kind. It's hard. And so my job was to protect the victim as best I could, but also, to protect the defendant's rights as we went through that case. So the truth is, sometimes for juries, because our system is really based on juries often require a victim that's perfect. And it's hard to find somebody really that's perfect enough in this system. I will just tell you, these are decisions that prosecutors really struggle with. I did as an assistant prosecutor. I've done that as the elected prosecutor to determine, is this case right? Did I make the right decision? Can I keep re-evaluating the evidence so I'm making a good call, I'm making a good judgment? And then, can my victim really withstand this process? Where is she, in her mental health treatment or, receiving help throughout her life? Can she manage this too? And sometimes the answer's just no. And that's just the weight of our system. But I want to kind of try and end on a positive note, and that is even the system that wrongly convicted Kevin Strickland 44 years ago, and as you probably know, was released from prison, it was that same system. The same system that falsely convicted him is the same system that freed him. So sometimes we are far from perfect, and we should strive to be better. But I don't believe, I believe in our system, as imperfect as it is, as imperfect as I am, and I hope that we can improve.
Thank you, Prosecutor. And the next guest we have to talk to us tonight is Kansas City Police Department Division Commander Marissa Barnes. Please welcome her.
Good evening. So I'm here to give a law enforcement perspective on what was just presented. So what I can say is that things are changing in law enforcement, and they have to, obviously, by some of the things that we saw, and none of that would be allowed to go on today. Yes, is that better? Oh, there we go. Okay. So we're working really hard to build relationships with the community and rebuild the trust that was broken by situations such as what you saw today. And by building those relationships, we start to get to know people and know their stories so that they're not just another victim, another number, another arrest. Our department has taken steps to educate officers about domestic violence and trafficking, as well as how to better spot the signs of someone who may be in need of help, so that we can prevent them from being put in the system if it can be avoided. We also have social workers that are assigned to every division station. I can't tell you how treasured they are. They bring so many resources to the table and have been so helpful, and I believe that they've kept a lot of victims out of the system by getting them the resources they need and just listening. So I just want to end on there's always room for change, growth, and we continue to learn in hopes of combating the issues that were discussed here today. Thank you.
Thank you so much, Major Barnes. And after our last speaker concludes her remarks, we'll go to Q&A for the audience, and those questions will all be for Professor Goodmark, not our other three guests. And again, just a reminder to everybody, whatever you ask has to end in a question mark if you get up to the microphone. So our last speaker tonight is Judge Courtney Watchell. She's a municipal judge for Kansas City, Missouri's Domestic Violence Court. Please welcome Judge Watchell.
Good evening. Thank you to Alice Kitchen for inviting me to be here tonight, and also thank you to Leigh Goodmark for her thought-provoking presentation. I just wanted to use this short amount of time that I have to distinguish a few things from Ms. Goodmark's remarks from what's happening in Kansas City. First, the Kansas City Municipal Court does not arrest or jail or issue warrants for witnesses that fail to appear in court. However, I do want to acknowledge that there are more barriers for witnesses or victims or survivors, whichever terminology you prefer, than there are for defendants that are charged with domestic violence. The defendant has an attorney by law. The defendant has more legal protections. The victim seeking protection first is told to get an order of protection. They apply at the Jackson County Courthouse. If the defendant violates the order of protection, their charges are filed in the Kansas City Municipal Court. It's so complicated to figure out where you need to go to follow up with your obligations if you want to be involved in your case. And not to mention just life, right? The barriers that these victims face, childcare, taking off work, transportation, and the threat of retaliation. So it's not easy to participate in the system as a witness at all if you have the strength to do so. However, on the converse, a witness that does participate in the system may encounter services for the first time in their traumatic experience of domestic violence. Our court has dedicated advocates, and also we have 2 victim advocates every day in my courtroom from the community. So whoever they connect most closely with, they will be able to access further resources based on that relationship. The witness is only required to be present if the case is set for trial. So they don't have to be at every court date, and most cases are not set for trial. If there is a cooperative witness, they end in a guilty plea. With regards to the imperfect victim, I work in a DV specialty court, and I have the luxury of a lot of training on domestic violence, the dynamics, and the witnesses involved. And so does all of the staff working in my courtroom, the legal aid, the prosecutor, and I feel like that's a luxury because all we handle is domestic violence cases. We're also trained on human trafficking and those dynamics there. So when I am evaluating testimony, I have this background. If a survivor is acting out due to trauma, I'm not going to immediately try to hold them in contempt or something of that nature, because I understand that these women are traumatized. Let's see. There's absolutely more that Kansas City could do to improve victim safety for victims of domestic violence. No question. I am grateful for this opportunity here tonight to learn and to keep working.
Thank you very much, Judge, and we welcome back to the stage Professor Leigh Goodmark. And I'll be right over here during questions and answers. If you have a question, please come up to one of two microphones. Thank you.
Professor Goodmark.
Hi.
That was an amazing presentation.
Thank you.
I wanted to know if you could talk a little bit more about the promise and the potential of alternative forms of justice, whether it's, embedded in the court system through restorative justice or community-led transformative justice.
Absolutely. So if not this, right, if not this system, what? There are so many things that we could be doing differently, and one of them is thinking about accountability differently. So when we stop thinking about punishment and when we start thinking about accountability, that opens up vistas for us to think about things like transformative and restorative justice. So for those of you who are not familiar with those terms, transformative justice is really an umbrella term that's meant to talk about the ability to find accountability and healing through non-state systems, and particularly through non-punitive state systems. And that encompasses a range of different kinds of practices and different kinds of ideas. And one of them is restorative justice. We've talked a lot, there's a lot to talk about restorative justice now. Restorative justice essentially asks three questions. What was the harm? What was the impact of the harm? And what needs to be done to make it right? And restorative justice doesn't have to happen within a formal system. It is happening in communities all over the country already. The anti-violence movement, though, has traditionally been pretty hostile to restorative justice in the same way that we were hostile, and I say we because I identify as part of the movement. I should have said, I came to this as a victim side lawyer. I have represented victims of violence in various ways for 30 years. So my trajectory was from those civil systems and family law systems into the criminal work that I do now on behalf of victims. So restorative justice is the idea that we can do this all outside of these systems, that we can bring together people who've done harm and people who've been harmed in productive ways that enable the people who've done harm to take accountability for what they've done and have the community embed around them to ensure that someone feels safe and someone continues to be held accountable. I think there's tremendous promise in all of this. Not in every case, not for every person. I have kind of three bedrock rules personally around restorative justice. One is that the victim has to want to do it. Two is that the offender or the person who's done harm is willing to accept accountability for that harm. And three is that people with experience with gender-based violence are involved in the facilitation, because some of the concern has been around the dynamics between those two people. You have to have people who understand gender-based violence to be part of that facilitation. Restorative justice talks about a variety of different kinds of things. There are too many practices for me to talk about, but I think as we think about, if not the criminal system, then what? One of the big things we need to think about is community. We have largely abdicated our role of responding to harms to the criminal legal system. As a community, if we choose to reclaim it, we need to figure out what that's going to look like. I think transformative justice gives us an umbrella to think about it, and restorative justice a specific set of practices. Yes?
Thanks for coming. My question's about terminology. And when I was growing up in the 60s and 70s, abortions were called D&C, or the woman could get the necessary treatments. But since they call everything abortions now, we've lost that protection for women. And what can we do to fix it?
So that's probably a little off topic for me tonight. I don't disagree with you that it's important that we be thinking about access to reproductive justice for everybody. But I think that's a little outside of kind of my field of expertise tonight, and I'm sorry for that.
Oh, okay. I just seen it in the title, so I thought I'd ask.
Oh, so that said abolition, not abortion. And I did the same thing with one of my computer files the other day.
Oh, okay. Thank you.
Thank you.
And this may, oh, sorry. Go ahead, ma'am.
Okay. What do we do, though, in regard to looking at clemency and other kinds of policies when they become political issues and are distorted by that?
We have to amass political power. They are political processes. So when we talk about clemency, we're talking about going to a chief executive, whether that's a governor or a president, and asking them to do something that they don't like to do, which is to say, hey, the system might not have done exactly what it was supposed to do here. The system might have made a mistake. And so we leverage all of the resources that we have. And I can tell you a little bit of a story. So I had a client who was trafficked, and her trafficker was running all of his businesses through her, and she was prosecuted for tax fraud and convicted of federal tax fraud. And she was in prison for some period of time, and then she was released, and we sought a presidential pardon from her. Well, presidential pardon was submitted under President Obama, but it was considered under President Trump. And we went to John Cornyn, not somebody that I would normally hang out with, the Republican senator from Texas. You get a feel for who I am, probably not somebody I'm hanging out with on a regular basis. My client had really great ties to Cornyn's office because of the work that she had done. And I can show you on my phone what a presidential pardon looks like, because Donald Trump, in doing a lot of presidential pardons, also pardoned our client. That's not intuitive, right? Doesn't seem like the kind of thing we should have been able to pull off. But I'll use whatever I can to get my clients the relief that they deserve. And so we need to be thoughtful about making kind of these strategic alliances that we need in that moment without selling out our values, without doing things that we feel gross about. But I didn't have any problem with her going to Cornyn and getting Cornyn to go to Trump on her behalf. And that's why that happened. We also have to help chief executives think differently about these cases, to understand that many of our clients were convicted at a time when our understanding of intimate partner violence wasn't fantastic, that when context wasn't fully considered. In these cases, we need to give folks the context that they need to understand them. We need to tell the redemption story. You know, I have clients, Miss Bailey, that's my client. I love this woman. And she did everything that she was supposed to do for 31 years in prison. So we could go to the Republican governor and say to him, Governor Hogan, she's done what you wanted her to do. If you want to say she's rehabilitated, like my argument would be there was nothing to rehabilitate. She didn't do anything in the first place. But if you want me to say she's rehabilitated and she's remorseful, I will say those things. And she was willing to say, I am remorseful that I didn't immediately go to the police. I am remorseful that I was involved with a horrible, violent man, right? Who threatened her. They were in bed one night. He had his arm around her neck and said to her, do you think I could kill somebody? And then told her that he had killed somebody in her apartment. That's how she found out that this had happened, right? But I'll go to Governor Hogan and say she is rehabilitated if that's what it takes to get her out. So we need to be strategic, as we always are when we're lawyering these cases. We need to be willing to think about how far we're willing to go in these conversations. And we need to kind of keep pushing as a movement for incarcerated women. I think one thing that the anti-violence movement has done really poorly is that it has abandoned incarcerated women. It has not paid attention to the plight of incarcerated women. And Beth Ritchie has written that she doesn't know an incarcerated black woman who wasn't abused before she ended up in prison. I've never met a woman in prison who wasn't abused in some way. But we have abandoned them. As a movement, we need to make this our cause and take the political power that we have to persuade chief executives that this is something that they should care about too.
We'll take this last question from the audience, and then we have one from someone watching at home.
Thank you.
Yes, I have one question concerning the election that's coming up locally and nationally. Is there a website where I could get more information on candidates that would agree with what you said tonight? Because it's hard to research all that on my own.
I don't know about locally. You'd have to ask folks here about that. I'm an interloper from Baltimore. I love it when it's online and being taped and I say stuff that I shouldn't say, but I'm going to say it anyway. there is no one running for office that fully embraces these positions, to the best of my knowledge. They are hard positions, in locally or kind of nationally, that we could all vote for. You know, our current president was a prosecutor. The current Democratic nominee was a prosecutor. The Republican nominee is a felon, which is not, for me, not like, I got lots of felons who I love. I love a lot of people who've been convicted of a lot of stuff, but not receptive to these ideas. This is a grassroots effort, right? This is not going to be a top-down. This is going to be a bottom-up. This is working to prevent the construction of new jails as they get proposed. This is working to prevent the construction of new prisons. This is working when folks start to say, you know what, we really should criminalize coercive control because that's the way to deal with it. It's saying no, because that's going to come back on criminalized survivors. It's bottom-up work really much more than top-down work, I think. I'm sorry if that's not a satisfying answer.
Okay, and we've got one from someone watching at home. This person asks, trans women especially suffer from invisible abuse due to the perceived gender equality between them and male partners or elevation above female abusers. How are trans abuse rates discussed?
So trans abuse rates are horrific. If you want to think about who the most marginalized people in society are, it is incarcerated trans women of color, without a doubt. Their abuse rates are really through the roof. And when trans women are incarcerated particularly, that abuse becomes exponentially more acute. They are in danger because of the facilities that they are housed in, because so often in most parts of this country, trans women are not able to be housed with cis women, they are housed with cis men, and that inherently puts them in danger. And the way that prisons have chosen to deal with that danger is to put people in solitary confinement. Solitary confinement is torture. Don't misunderstand that. Right? Solitary confinement is torture. So we torture trans women for the fact that they are trans and incarcerated. So there is no group of people who is more need of our care, our attention, our advocacy than trans women who are almost all of them criminalized survivors.
Thank you very much. Thank you all for being here, and thank you, Leigh Goodmark.
Thank you so much for having me.